Director, the first time you saw Donald Trump's name was in the Epstein Files. Did you close the files or keep reading?
I have reviewed not the entirety of the files, so I have...
You haven't reviewed all of the Epstein Files?
Personally, no.
You're the director of the FBI. This is the largest sex trafficking case the FBI has ever been a part of. Buck stops at the top, and your testimony today is you have not reviewed all of the files.
What I've been doing is been busy providing the safest country this country has seen in modern U.S. history in historic speed, because the men and women of the FBI are given the resources to reduce the homicide rate, to reduce the drug trafficking rate, to reduce the amount of children that are being trafficked and the number of pedophiles.
It sounds like those children being trafficked would appreciate the director reviewing the files. You said you don't know the number of times Trump's name appears in the files, so it could at least be 1,000 times. Is that right?
Imagine walking into a hearing room and watching the director of the FBI handle the Epstein files like a cashier who lost the receipt but still swears the total is correct. That was the shock inside this congressional clash, where Kash Patel, the FBI director, was pressed about Donald Trump's name in the Epstein Files, the largest sex trafficking case the FBI has ever touched. And one question cut through the room like a blade. Did he actually read the files himself? And Patel's answer was not a clean yes. He said he had not reviewed the entirety of the files personally. That is where this stopped being a normal oversight hearing and turned into something much sharper, because the man at the top of the FBI was being asked about one of the most radioactive document sets in modern American politics, and his defense began with a gap big enough to drive a subpoena truck through.
The number is a total misleading factor. We have not released anyone's name in the Epstein files that has not been credible.
Director, could it at least be 1,000 times?
We have released every piece of legally permissible information.
Okay,
you can characterize the numbers however you want it.
I'm claiming my time, Director. It sounds like if you don't know the number, it could at least be 1,000 times.
It's not. It's not.
Is it at least 500 times?
No.
Is it at least 100 times?
No.
Then what's the number?
I don't know the number, but it's not that.
Do you think it might be your job to know the number?
My job is to provide for the safety and security of this country. My job is not to engage in political innuendo so you can go out to the sticks and get your 20-second hit in your fundraising article. Keep going, reclaiming your time, because the people of California are being underserved by your representation.
If the president is not implicated, why not release everything that involves him?
We have released everything, the president and anyone else's side, that is credible and lawfully be able to be released. Your fixation on this matter and baseless accusations that I'm hiding child pedophiles is disgusting.
The congressman did not start with poetry. He started with control. He asked whether Patel closed the files when he first saw Donald Trump's name, or whether he kept reading. That question mattered because it was not just about curiosity, gossip, or cable news drama. It was about whether the FBI director knew what was inside the files before telling the public what was credible, what was lawful, and what could be released. Then came the pressure point. If Kash Patel did not know how many times Donald Trump's name appeared, could it be 1,000 times? Patel said no. Could it be 500? No. Could it be 100? No. Then what was the number? Patel said he did not know. And that is the contradiction sitting right in the open. He rejected the numbers, but admitted he did not know the number. In prosecutorial terms, that is not a small stumble. That is the witness saying, "I cannot tell you what the ledger says, but I promise you, your estimate is wrong."
Anyone that says that needs to look at the stats alone and go back to the state of California, who's receiving the biggest surge in FBI resources through my redeployment, because the cities of Los Angeles, San Diego, and San Francisco need it.
Director, remembering your oath to tell the truth, did you ever tell Donald Trump his name is in the files?
I have never spoken to President Trump about the Epstein files.
Did you ever tell the Attorney General that Donald Trump's name is in the Epstein files?
The Attorney General and I have had numerous discussions about the entirety of the Epstein files and the reviews conducted by our team.
Did you tell the Attorney General that Donald Trump's name is in the Epstein files?
And we have released where President Trump's name is in the Attorney's files.
It's a simple question. Did you tell the Attorney General that the President's name is in the Epstein files?
During many conversations that the Attorney General and I have had on the matter of Epstein, we have reviewed.
The question is simple.
Who
did you tell the Attorney General that Donald Trump's name is in the Epstein files? Yes or no?
Why don't you try spelling it out?
Yes or no, Director?
Use the alphabet.
Yes or no?
No? A, B, C,
Director,
D, E, F?
it sounds like you don't want to tell us. Did you tell the Attorney General that Donald Trump's name was in the Epstein files?
Why don't you try serving your constituency by focusing on reducing violent crime in this country and the number of pedophiles that are illegally harbored in your sanctuary cities in California? I'll work with you on that.
Regular order, Mr. Chairman.
I
belong to the gentleman from California.
Did you tell the Attorney General that Donald Trump's name is in the Epstein Files?
The question has been asked and answered.
You've not answered it, and we will take your evasiveness as a consciousness of guilt. Director, did Donald Trump ever say to you, just find and release the entire truth? Don't worry if I'm in it.
The instructions from the administration were to release all credible information, and we have done that.
Did Donald Trump ever provide information about Jeffrey Epstein as an informant?
The room did not need fireworks at that point. The math was already smoking. And this is where Kash Patel's answer began to look less like testimony and more like a defensive smoke machine turned on in the middle of a courtroom. Because instead of giving a direct number, instead of saying, here is what the FBI reviewed, here is what I personally saw, here is what the Attorney General was told, Patel started moving the conversation away from Epstein Files and toward crime rates, homicide reduction, drug trafficking, child trafficking, FBI resources, and California. Now, those issues matter. No serious person says violent crime or child exploitation is irrelevant. But when the question is whether the FBI director knows what is inside the Epstein files, a speech about general law enforcement success does not answer the question. It buries it under patriotic fog. That is the first real prosecutorial problem. A witness can say many true things and still avoid the only thing that matters. Patel said his job was to provide safety and security for the country, not to engage in political innuendo. That sounds clean until you remember the actual question was not, do you like political innuendo? The actual question was, did you know how many times Donald Trump's name appeared in the Epstein files, and did you tell anyone at the top of the Justice Department? Then the congressman tightened the frame. He asked Patel whether he ever told Donald Trump that Donald Trump's name was in the Epstein files. Patel answered that he had never spoken to President Trump about the Epstein files. That was one of the cleaner answers of the hearing, and for a moment it looked like the line might hold. But the next question was sharper. Did Kash Patel tell the Attorney General that Donald Trump's name was in the Epstein files? That is when the answer started bending again. Patel said he and the Attorney General had numerous discussions about the entirety of the Epstein files and the reviews conducted by the team. But that is not the same as answering yes or no. The question was not whether they had numerous discussions. The question was whether Patel told the Attorney General one specific fact, that Donald Trump's name was in the Epstein files. In any normal workplace, if your boss asks, did you tell legal about the warning label? And you answer, we had many discussions about product safety. Everybody in the room knows what just happened. You did not answer. You wrapped the answer in bubble wrap and hoped nobody noticed the box was empty. The congressman noticed. He pressed again and again, yes or no. And Patel snapped back with insults, telling him to try spelling it out, then pivoting into attacks about California, violent crime, sanctuary cities, and political performance. That moment mattered because anger can be revealing. Not because anger proves guilt, but because anger often shows where the pressure point is.
Donald Trump has not been, and I can only speak for the FBI, an informant of the FBI.
So, Director, you've played this cute shell game where you say you can't release everything because the court has said that it legally is not allowed to be released, but the court calls bullshit. Judge Richard Berman said that when you went to the court, quote, information contained in the Epstein grand jury transcripts pales in comparison to Epstein investigation information and materials in the hands of the Department of Justice. So let's move on, Director. You wrote a book called Government Gangsters. You identified 20 individuals in that book. You put me on that list at the top of the list. Thank you. My children find it flattering. 20 of those individuals have been investigated or have had adverse actions. Director, considering that you have identified these people as, quote, government gangsters, will you recuse yourself from making any investigation decisions about these individuals?
Anyone that has been terminated at the FBI has been done
No, the question
they failed to meet the muster in their
Director,
constitutional obligation.
I will work on the audio-visual capabilities.
I'm going to borrow your terminology and call bullshit on your entire career in Congress.
I'm reclaiming my time,
It has been a disgrace to the American
Director,
people.
I'm reclaiming my time.
You can reclaim your time all you want.
Mr. Chairman, you're going to allow a witness to speak this way? Mr. Chairman, would you give...
Recuse yourself, Director.
The gentleman has no time.
Mr. Chairman, would you admonish the witness not to insult members?
The gentleman has no time.
Mr. Chairman, just...
The committee will remember...
Quick point of order. Could the gentleman be extended an additional 20 seconds to complete
his thoughts since the witness decided to interrupt him continuously.
And the witness will be able to respond if he wants. We'll make sure he has time to do that.
My question is,
continue.
will you, Director, recuse yourself, yes or no, from investigating or making decisions about the 60 individuals, including myself, that you identified as government gangsters? Yes or no?
Time of the gentleman has expired. The
No.
witness may respond if he would like.
And the answer was no, as I heard.
Correct.
Okay. The gentleman.
When a witness is calm on broad policy but suddenly turns combative on one narrow factual question, the room learns something about the question. It learns that the question landed. And this is where the moral scene begins to form. Because behind every legal phrase in this exchange, behind credible information, lawfully released, grand jury transcripts, and review conducted by our team, there are victims whose lives were treated like disposable evidence in a power network protected by money, access, and silence. The Epstein case is not a celebrity guessing game. It is not a partisan carnival booth where people throw accusations and collect clicks. It is a test of whether powerful names get handled with the same cold honesty as unknown names. So when the FBI director says he has not personally reviewed all the files, does not know the number, but still pushes back on the number, the public is allowed to ask a brutal question. Are we watching law enforcement, or are we watching damage control with a badge on it? That is why this exchange hit so hard. It was not only about Donald Trump. It was about whether the institution asking the country for trust is willing to earn that trust with direct answers. Because if the FBI can demand obedience from ordinary people, then the FBI director can survive one simple question in Congress without hiding behind a speech about California. And if he cannot, then the silence becomes part of the evidence. Then the hearing shifted from the Epstein Files into something even more dangerous for Kash Patel, the record outside the room. The congressman brought up Judge Richard Berman, and that name changed the entire temperature of the exchange. Because Patel had been leaning on the idea that some material could not be released legally, that courts had limits, that grand jury material was protected, that the FBI and the Department of Justice had released what was credible and lawful. But then came the receipt. Judge Berman said the information inside the Epstein grand jury transcripts pales in comparison to the Epstein investigation information and materials still in the hands of the Department of Justice. That was not some random comment from a blogger screaming into the internet. That was a federal judge pointing out that the grand jury material was not the whole ocean. It was a cup of water compared to what DOJ already had. And that matters because Patel's defense sounded like a locked door, but Berman's statement made it look more like a curtain. The question was no longer simply, can the court release this narrow category of material? The question became, what else is sitting inside the Department of Justice and the FBI that does not depend on grand jury secrecy at all? That is where the legal argument starts tightening around Patel's testimony. If the FBI says, we released everything legally permissible, then the public has a right to ask who defined permissible, who defined credible, who reviewed the material, and why the FBI director himself had not personally reviewed all of it. Because credible is not a magic word. Legally permissible is not a shield you can hold up without showing how the decision was made. And when the public is dealing with Epstein Files, powerful names, hidden networks, and victims who waited years for sunlight, vague institutional language starts sounding less like law and more like insulation. Then the congressman moved to Patel's own book, Government Gangsters. That was not a side issue. That was a second indictment of judgment. Patel had identified individuals in that book, including the congressman himself, and labeled them as part of a corrupt government class. So the question became brutally simple. If Kash Patel has already publicly branded people as government gangsters, can he fairly oversee or influence investigative decisions touching those same people? That is not a question about wounded feelings. That is a question about conflict of interest. If a judge wrote a book calling a defendant a criminal before trial, no serious person would call recusal a cute procedural trick. They would call it basic fairness. If a prosecutor publicly named enemies before taking office, then later claimed full authority over cases involving those names, the public would not need a law degree to smell the problem. Patel's answer did not soften the room. He defended the actions, said terminations at the FBI involved people who failed constitutional obligations, and then the exchange deteriorated into open contempt. Patel called the congressman's career in Congress a disgrace. That line was not just rude, it was revealing. Because the more the questions narrowed around duty, disclosure, and recusal, the more the answer widened into personal attack. And that is the pattern this hearing exposed. Ask about Epstein Files, get a speech about crime. Ask about Trump's name, get a fight over political innuendo. Ask about the Attorney General, get numerous discussions. Ask about recusal, get contempt. In a courtroom, that pattern would not end the case. It would point the jury toward the missing answer. And morally, this is the part that should bother everyone watching. The victims in the Epstein case did not need another powerful man turning accountability into theater. They needed institutions willing to say, here is what we know, here is what we do not know, here is what the law blocks, and here is what we can still release. Instead, the country watched the FBI director fight harder against the question than against the suspicion the question created. And when the person holding the files cannot explain the files cleanly, the damage is not only political. The damage is civic. Because every evasive answer teaches ordinary Americans that power still has a private language, and that language sounds a lot like "trust us" spoken through clenched teeth. So the final question is not whether Kash Patel can win a shouting match in Congress. The final question is whether the FBI director understands that public trust is not a trophy you get for holding a powerful title. You earn it by answering the narrow question when the narrow question is uncomfortable. You earn it by separating law enforcement from loyalty tests, separating legal limits from political convenience, and separating victim justice from institutional self-protection. Because in this hearing, the most damaging thing was not one insult, one interruption, or one sarcastic exchange. The most damaging thing was the pattern. Kash Patel said he had not personally reviewed all the Epstein files, but still rejected specific numerical guesses. He said the FBI released what was credible and lawful, but did not clearly explain the full decision trail behind that claim. He said he never talked to Donald Trump about the Epstein files, but when asked about the Attorney General, the answer became foggy, layered, and evasive. Then when asked about recusal from matters involving people he had branded in government gangsters, the answer landed like a slammed door. That is why this moment matters beyond party politics. This is not about whether someone likes Donald Trump, hates Donald Trump, trusts Kash Patel, or dislikes the congressman asking the questions. This is about whether the law can look powerful people in the face without blinking. It is about whether victims in a massive sex trafficking case are owed sunlight, or whether they are expected to accept another round of sealed language, selective disclosure, and bureaucratic confidence. And personally, I think that is the real moral wound here. The system keeps asking ordinary Americans to trust institutions that often refuse to explain themselves when the names get too powerful. A poor defendant does not get to say, "I reviewed some of the evidence, trust me on the rest." A victim does not get justice from a press line. A country does not rebuild faith through evasive answers wrapped in patriotic slogans. So here is the question that should stay with every viewer. If the FBI director cannot give clean answers about the Epstein files in public, why should the public believe the private process was clean? Drop your thoughts in the comments, because this is exactly the kind of hearing that deserves public pressure, not public silence. Like this video, share it with someone who still thinks oversight is just political theater, and subscribe for more hearing breakdowns where the receipts matter more than the spin.